You erased his accommodation on a Sunday night, and by Monday morning you were calling him unreliable. Judge Caprio said it so evenly that the quiet afterward felt heavier than a shout. I watched the defendant at the far table blink twice, like he thought calm words were easier to survive than anger, and then realized they weren't. The whole room seemed to tighten around that sentence. From where I sat in the middle row of courtroom 3B, I could see the veteran's cane leaning against counsel table, the rubber tip worn down on one side. I could also see the chief operations officer of the tech firm trying to hold on to his boardroom face, chin up, jaw set, fingers linked in front of him, like this was still a strategy session he could manage. But Judge Caprio had already reached the center of it, and everybody in that courtroom knew it. This happened on a rainy Tuesday morning, January 16, 2024, in Providence County Superior Court. I'd come expecting another employment dispute with dense paperwork and tired legal language. I had no idea I was about to watch a case peel back the polished skin of a successful company and expose something mean underneath. Before I tell you exactly what happened next, I want to know where you're watching this from. Drop a comment with your location. And if you haven't subscribed yet, go ahead and hit that button now, because what unfolded in that courtroom is something you need to see. The courtroom smelled faintly of wet wool, copier paper, and old varnish. Rain tapped against the high windows in an uneven rhythm, and the radiator along the left wall kept making dry metal clicks as if it objected to the weather. The fluorescent lights hummed overhead, washing every face in the same pale brightness. But even under that flat light, I could tell who was scared, who was angry, and who had come in thinking money would carry them through. The plaintiff was Leonard Velez, 52, a Navy veteran who had spent 17 years working in cybersecurity operations for a Providence tech company called Halcyon Grid Solutions. He wore a navy blazer and a light gray tie, and he stood with the careful stiffness of a man who measured each movement before making it. His left hand opened and closed at odd moments, like the nerves weren't fully cooperating, and every time he shifted his weight, I could see him brace through a flash of pain he didn't want to advertise. Behind him sat his daughter Elena in a dark green sweater, her hands locked together in her lap. She looked young, maybe 20, but there was an older kind of worry in her face, the kind people get after watching someone they love fight the same battle too many times. Beside her sat Miss Celia Ramos, Leonard's aunt, silver braids pinned under a burgundy knit hat, eyes alert and unblinking. On the other side of the room were 3 Halcyon employees in expensive coats, trying to look neutral and failing. The bailiff had called the matter just after the morning recess. Leonard was suing Halcyon for disability discrimination, retaliation, failure to accommodate, and destruction of evidence. The issue at the center of everything was an accommodation plan that had existed in the company's system for years and then vanished in October 2023, just before a company-wide push to end flexible work arrangements. Judge Caprio sat at the bench with his reading glasses low on his nose and a yellow legal pad beside him filled with narrow, precise handwriting. He didn't waste movement. He didn't fidget with papers to create drama. He listened the way some surgeons work, patient and exact, and when he looked up at a witness, it felt like he was measuring both the answer and the reason behind it. Leonard's lawyer, Samuel Reardon, was the kind of attorney whose strength came from restraint. He was broad-shouldered, gray-haired, and almost plain in his manner until he opened a binder and started laying out dates. Mr. Velez had a documented disability accommodation plan beginning in 2019, he said. That plan included glare reduction at his workstation, speech-to-text software during neuropathy episodes, 2 remote days during migraine cycles, and flexibility for VA neurology appointments. Judge Caprio turned to Leonard. Those accommodations allowed you to do your job? Yes, sir, Leonard answered. His voice was low and rough but steady. They didn't give me an advantage. They kept me functional. That line moved through the room. A woman behind me murmured, "That's right," under her breath before catching herself. One of the law students near the aisle stopped writing for a second and just looked up. Even the court reporter glanced at Leonard over the top of her screen before resuming her typing. Reardon walked the court through Leonard's history, In 2005, outside Mosul, the communications convoy he was attached to took a blast that left him with a traumatic brain injury, vestibular dysfunction, chronic migraines, light sensitivity, and nerve damage in his left hand. None of that had kept him from building a career after service. He learned systems architecture, worked his way up, trained younger analysts, and by 2022 he was one of Halcyon's senior incident response specialists. "Did your employer know about your condition?" the judge asked. Leonard nodded. "From the day I was hired, they had medical documentation. They had annual reviews mentioning the accommodations. I was never hiding." "And how was your performance?" Leonard hesitated, not out of uncertainty but out of modesty. "Strong, Your Honor. I led breach response teams. I trained new hires. I got 2 Excellence Awards." Reardon passed up copies of those awards, and I watched Judge Caprio study them in silence. Across the room, Halcyon's Chief Operations Officer, Evan Pike, kept his face composed, but he had started rubbing his thumb over the edge of his cuff in a quick, repetitive motion. Small habits tell the truth faster than polished statements do. The defense attorney, Denise Holbrook, stood and said Halcyon regretted what happened, but insisted the accommodation record disappeared during a software migration. She called it an unfortunate administrative failure. The phrase sounded clean in her mouth, almost sterile, and that made it worse. Judge Caprio asked Leonard what happened after the file was deleted. Leonard took a breath before answering. "On October 23rd, I logged in and the speech software license was gone. My remote access authorization was gone too. A week later, they moved me under these bright overhead panels on the 4th floor. I told HR there had to be a mistake. They said there was no active accommodation on file." I heard Elena draw in a breath through her nose and hold it. Miss Celia shook her head slowly, lips pressed together. Somewhere near the back, a chair creaked because somebody had leaned forward too fast. Leonard continued. "Then they started saying I wasn't adapting, said I lacked full spectrum availability." He gave a dry, humorless laugh that lasted less than a second. "That's what they called it." The judge leaned forward. "What did that mean in practice?" "It meant if I got dizzy under the lights, that was an attitude issue. If I asked for time to go to VA neurology, that was poor team alignment. If I couldn't type fast during a neuropathy flare because they'd taken the software away, they marked productivity concerns. That was when the shape of the cruelty came into focus. This wasn't about one lost form. It was about taking away the support, then blaming the man when the injury showed up exactly where the support used to be. Reardon called Trevor Bell, Leonard's direct supervisor. Trevor looked like he regretted wearing such a bright tie. Under oath, he admitted Leonard had been a strong employee for years. When asked what changed, he said, "There was concern about responsiveness and availability in the 4th quarter." "Before or after the accommodation file vanished?" Reardon asked. Trevor swallowed. "After. Before that, did you ever recommend discipline?" "No." Judge Caprio looked at him over his glasses. "So his performance collapsed at precisely the moment his protections were removed?" Trevor's ears went red. "That's how the timing appears, yes." The silence after that wasn't empty. It was packed with recognition. A young man in the row ahead of me leaned back and covered his mouth with one hand. The older gentleman beside the wall folded his arms and stared hard at the defense table. Nobody needed a legal education to understand what that answer meant. Then Reardon called Priya Nandor from Halcyon's internal IT team. She was neat, serious, and plainly uncomfortable being there. I watched her take the oath with one hand trembling just enough to notice. She explained that accommodation profiles in the company's HR system were not auto-deleted during migration. They required administrator action. "Was Mr. Velez's record automatically removed?" Reardon asked. "No," Priya said. "Was there a log?" "Yes." "And whose credentials were used?" Priya glanced down once, then answered, "Marisol Trent's, Vice President of People Operations, October 22nd, 8:14 p.m. A rustle moved through the gallery like wind through dry paper. One of the Halcyon employees in the back shifted in his seat and stared at the floor. Elena's eyes went wide, but Leonard didn't turn around to look at her. He kept his gaze fixed on the witness stand, as though he had been waiting months to hear someone say the truth out loud. Denise Holbrook tried to soften it. Credentials can be used by others, she said. Priya answered carefully. They can, but sharing them violates company policy. Judge Caprio wrote something down. Then he asked, was anything else changed after Mr. Velez complained internally? Priya took a moment before answering. Yes, metadata connected to user attribution in the active environment was cleared, but I had preserved a mirrored backup from the prior night, so the original log still exists. That landed harder than anything so far. Evidence hadn't merely been neglected, it had been altered after a complaint. Miss Celia closed her eyes and whispered something that sounded like prayer. The law student near the aisle underlined 3 lines in his notebook, so hard I could hear the pen digging into paper. Next came the internal messages. Reardon entered a Slack thread from October 21st. He read it in a plain voice, and that plainness made it feel even colder. One message from Marisol Trent said, if we keep every special case alive in the system, we'll never normalize accountability. Another from Evan Pike said, purge legacy exceptions before Q4 review. Legal can handle wording. Denise objected. The judge overruled her. Reardon read one more line. LV is the biggest barrier to uniform in-office compliance. I watched Leonard's face as those words entered the room. He didn't look surprised. He looked tired in a way that reached the bone. There is a special kind of hurt in hearing suspicion become proof. Elena lowered her head and pressed the heel of her hand to one eye. A woman 2 rows behind me made a small sound, something between a sigh and disbelief. When it was Evan Pike's turn to testify, he strode to the stand, like he still thought tone could outrun content. He was in a charcoal suit, sharp haircut, bright watch, the kind of man who probably spoke in bullet points even at dinner. But from where I sat, I could see that one knee bouncing under the witness chair. Reardon asked him about exception reduction language in a November investor presentation. Pike answered, it referred to eliminating non-standard workflow inefficiencies. Did disability accommodations fall under those inefficiencies? Reardon asked, not as a category. In Mr. Velez's case? Pike paused. The company was moving toward consistency. Judge Caprio lifted his head. Consistency for whom? Pike shifted. For the workforce overall. The judge didn't blink. That is not an answer. Consistency for whom? Pike tried again. For business operations. Then Judge Caprio said something I wrote down the moment I heard it. When executives stop naming people and start naming operations, somebody vulnerable is usually about to pay the bill. That line traveled through the room and settled into people. The woman in front of me nodded without looking away from the bench. Reardon showed Pike an email sent at 11:17 p.m. on November 8th. The subject line was Q4 Discipline Optics. In it, Pike wrote, we can't let one veteran become the model for special treatment while the rest of the company resets. He called it poor phrasing. Judge Caprio's mouth tightened. Poor phrasing, the judge said. I've heard that excuse from your table all day. Words are not spills on a carpet. They reveal priorities. Pike straightened in the chair. With respect, Your Honor, this was about maintaining standards. No, Judge Caprio replied, voice still level. It was about removing a disabled employee's support structure and rebranding his resulting struggle as a personal failure. Standards were the costume. That hit the room like a dropped weight. The older man by the wall let out a breath that sounded almost painful. One of the Halcyon employees closed his eyes and rubbed his forehead. Even Denise Holbrook stopped writing for a moment. Marisol Trent testified after Pike, and her composure lasted less time. She insisted the company was overwhelmed by a system transition and denied any intention to target Leonard. Reardon asked if she had ever met Leonard before the termination meeting. No, she said. Ever sat at his workstation? No. Ever watched him try to work under bright overhead lighting? No. Ever attended one of his VA accommodation reviews? No. Reardon took a step back. But you deleted the file. Her lips parted, then closed. I inactivated a record I believed was outdated. Judge Caprio leaned forward. Outdated because the employee no longer needed it, or outdated because the company no longer wanted to honor it? She didn't answer right away. That pause said more than a clean denial would have. I heard whispers ripple through the last two rows before the bailiff turned and quieted them with a look. By late afternoon, the rain had strengthened, and the courtroom windows held a dull silver light. Closing arguments were brief because by then the evidence felt almost arranged by its own gravity. Reardon told the court, "My client served his country, disclosed his injuries, performed with distinction, and then lost the very tools that let him work. The company then turned his pain into documentation against him." Denise argued there had been sloppiness, not malice. She said Halcyon had grown quickly, made mistakes, and deserved the chance to correct them without being defined by one flawed process. But nobody in that room believed this was just one flawed process anymore. It was a pattern with emails, logs, timing, and language all pointing the same direction. When Judge Caprio returned to rule, the whole courtroom went still. He removed his glasses and placed them on the bench as carefully as if setting down a measuring instrument. Then he looked at Leonard first. "A disability accommodation," he began, "is not a favor. It is a recognition of reality." His voice carried easily, not loud, just exact. Reality does not disappear because someone with authority finds it inconvenient. Elena's face crumpled then, quietly. She bowed her head and wiped tears with the side of her hand. Leonard stayed upright, but his fingers gripped the table edge so hard the knuckles blanched. The judge laid out the facts one by one. Leonard Velez had a valid and long-standing accommodation plan. Halcyon knew of it. A senior executive used administrative credentials to deactivate it. The company then stripped away his supports, treated the resulting medical impact as a behavioral problem, and altered metadata after a complaint was filed. Then Judge Caprio said, "You cannot remove the ramp and then write a man up for not climbing stairs fast enough." A murmur of agreement moved through the gallery before settling again. The line was simple, but it hit with perfect force because everybody in that room understood it immediately. He found for Leonard on failure to accommodate disability discrimination, retaliation, and spoliation of evidence, back pay, lost benefits, emotional distress damages, punitive damages. The numbers mattered, and they were large enough to wipe the color from Evan Pike's face, but that wasn't what made the ruling unforgettable. What made it unforgettable was the part tailored exactly to the harm. Judge Caprio ordered Halcyon to install a tamper-proof accommodation tracking system overseen by an independent monitor for 3 years. No accommodation request, approval, denial, or modification could be deleted without leaving a permanent external audit trail. Quarterly compliance reports would be filed under oath. The company would fund a $500,000 Rhode Island training program for disabled veterans entering technology careers, with Leonard consulted on its design. It would also pay for Leonard's adaptive technology and independent career placement wherever he chose to work next. That was the moment the punishment fit so perfectly, it almost felt architectural. They had erased a disabled veteran's support to make him invisible inside their system. Now the court was forcing them to build a system that could never hide a person like that again. I heard Miss Celia whisper, "That's right, Judge." The young veteran in the front row wiped both cheeks with the heel of his hand and didn't seem ashamed of it. One of the law students just stared ahead, pen forgotten in his fingers, like he knew he'd just seen a lesson no textbook explains properly. Judge Caprio wasn't finished. He looked straight at Halcyon's executives and said, "If you sell technology that promises fairness, then fairness begins in your own building. People are not defects in a workflow. Disabled employees are not rounding errors. And a veteran's injury is not an obstacle to be cleared before quarter-end reporting." The room held that silence the way churches hold certain songs after the last note. Pike asked if the court would stay the compliance reforms pending appeal. Judge Caprio answered without hesitation, "No. Delay helped create this harm. This court will not reward it." That line broke something loose in the room. Not noise exactly, but release. A man behind me breathed out so deeply it sounded like months leaving his body. Elena leaned against her father's shoulder, careful of his balance, and Leonard finally shut his eyes for 1 second, as if he could let the weight drop now. As adjournment was called, I watched people rise slowly, Reluctant to break the moment, Reardon clasped Leonard's hand in both of his. Priya Nandor slipped out through the side aisle, face pale but lighter somehow, like truth had frightened her but also freed her. Marisol Trent stayed seated longer than the others, staring at the tabletop with the fixed look of someone who had just realized procedure can't protect a conscience forever. I remained where I was for a minute after the bench cleared. Rain softened against the windows, papers rustled, the bailiff stacked files with practiced hands. Leonard turned to Elena and said something too quiet for me to hear, and for the first time that day she laughed through tears. It was small and shaky and completely human, and it struck me harder than any raised voice had. Walking out of that courthouse, I kept thinking about how often harm arrives wearing polished language. Alignment, efficiency, consistency, reset. Those words had been used to dress up the deletion of a disabled man's lifeline. Judge Caprio stripped all that language away and named the act for what it was. Real justice, at least that day, did more than punish. It translated pain into a record nobody could distort later. It made the powerful pay in the exact place they had sinned. They had manipulated the system, so the system was taken out of their private hands. They had treated accommodation like clutter, so now accommodation would be monitored, permanent, and public. So I want to ask you, if a company makes it harder for a disabled employee to function and then blames that employee for struggling, what should accountability look like? And here's what keeps me wondering. How many decent workers have lost jobs not because they failed, but because somebody in authority quietly decided their needs were too inconvenient to keep on file? Tell me in the comments what you think about this situation. Do you agree with how Judge Caprio handled it? Let me know below. If this story hit you the way it hit me, hit that like button. Subscribe to see more real courtroom moments like this. Share this with someone who needs to see real justice. There's another powerful story waiting in the next video. I'll see you tomorrow with another story you won't believe.